Today we are going to have a brief discussion about the prevention principle. By the way, if you're not familiar with time barring clauses or the concept of time at large, please check out my other videos on these subjects. I would strongly recommend that you do this before you watch this presentation because the prevention principle is closely linked with these issues. So what is the prevention principle all about? Now, one of the contractor's defense against a time barring clause centers around a generally stated legal principle that a party cannot benefit from its own wrong. This is what is popularly known as the prevention principle. This legal concept is generally accepted in several countries. For example, if the employer critically delays the contractor by not providing design information on time, and the contractor is also not given an extension of time to the contract duration for the same, the employer will benefit by being able to levy penalties or liquidated damages for a delay that he caused. This type of recovery is not legally allowed in most countries. It should be noted that an extension of time clause was included within modern forms of contracts to prevent arguments related to the prevention principle and time at large. However, just because a contract has an extension of time clause, it does not mean that the arguments related to time at large and prevention principle cannot be raised. Here are a few cases that support the prevention principle. Peak Construction Liverpool Limited versus McKinney Foundations Limited, Gaymark Investments versus Walter Construction Group, Peninsula Balmain versus Abbey Group Contractors, Roberts versus the Berry Improvement Commissioners, and Home versus Guppy. However, there is conflicting case law on this subject. The difficulty between the prevention principle and time barring clauses has also been considered in Australia and to a lesser degree in Scotland. The approaches in these jurisdictions may provide guidance to construction arbitrators. The notable cases that are commonly cited in support of time barring clauses, i.e. against the prevention principle, are the Australian cases of Turner Corporation Limited versus Coordinated Industries and Decor Sealing versus Cox Constructions, and the Scottish case of City Inns Limited versus Shepherd Construction Limited. There are also some new cases on the subject, and they are Steria versus Sigma, Multiplex versus Honeywell, and Waterfront Shipping versus Trafigura. So what is the conclusion? Unfortunately, there is no simple answer, and the issues that arise on projects should be studied on a case-by-case basis. The effectiveness of a time-barring clause depends on several issues, including the legal jurisdiction that the contract is being administered in, the precise nature of the event, and various other issues. For example, some jurisdictions would view a situation related to a lack of notice for a minor compensation event differently from one that is related to a major compensation event. If a contract contains a time bar clause, contractors should make sure that they comply with the requirements of the same in terms of the time that it is submitted, format, and effective service of the notification. This is vital given that time barring provisions are a common feature of many standard forms of contracts, including the NEC 3 and FIDIC. In particular, contractors should not assume that general references to delay and/or loss or expense during the course of the works are sufficient to satisfy time barring provisions. Employers should be careful about rejecting claims just because a notice was not submitted on time, especially if it was obvious that a variation or an act by the employer and/or his representatives would have delayed the contractor. That's all. Thank you for watching.